Welcome to an Awarelogue special. In an age of heightened international disputes, we see a convergence of law and diplomacy. Much has been unfolding in this sphere of activity, and we are happy that a senior academic in the United States of America joined us for this session to highlight law and diplomacy. Our guest on this Awarelogue special is Professor Karunaratne Hangawatte, Professor of Criminal Justice at the University of Nevada in Las Vegas in the USA. He has served as ambassador of Sri Lanka to France, Spain, and Portugal, and was also ambassador to the United Nations Educational, Scientific, and Cultural Organization and the United Nations World Tourism Organization. In 2013, he chaired the 19th session of the General Assembly of States Parties of World Heritage at UNESCO.
It is in the recent times, there has been more and more convergence of law and diplomacy in terms of international relations, international trade and investments, especially. And of course, the relationship between law and diplomacy started a long time ago, right? With Prof, who wrote even a book on that. So, since then, it was mostly diplomacy that was used by countries to settle disputes between and among them. Having said that, let me start off by saying how law becomes important when it comes to diplomacy and international relations. Peace is the dominant objective or the ideal of human existence. Both law and diplomacy are tools that help achieve peace. So philosophically, peace is synonymous with non-violence, right? And if we look at the Anglo-American, I have to refer to Anglo-American jurisprudence, that's what I have studied. Anglo-American jurisprudence classifies violence into two categories. Legitimate violence, that is where the intended end of violence is non-violence, that is legitimate. Example, self-defense is legitimate. Non-violent protest, legitimate. Freedom fighting, legal sanctions, like punishments by courts, they are all legitimate. Although they are violent, they are legitimate because the end is non-violence. Then there's illegitimate violence, where the intended end is violence itself. Example, retaliation. If somebody hit you, you hit back, retaliation, then you get, so that causes more violence. Okay. Coerced confessions, instead of taking a confession legally, in legal ways, coerced confession. Police brutality. General police actions are legitimate, but police brutality, for example, and even terrorism is considered illegitimate violence compared to freedom fighting, which is legitimate violence, or even peaceful protest is legitimate violence. Okay. Having said that, I don't want to go into that too much. Diplomacy and law have played major roles in bringing about peace among communities, within states, and also between nations. So that's that. In other words, what I so far said was the purpose of both the law, main purpose, both the law and the diplomacy are the same, basically. Let me give another couple of examples how this plays in the international relations. For example, let's say a brutal dictator may govern by brutally oppressing the opposition with murder, long-term incommunicado detentions without trial, etc. And by enacting laws that permit such governmental violence against the citizens. So they will say we are justified, we are acting according to law, right? Does that mean they are upholding the rule of law? Because remember, rule of law is also another very important concept when it comes to diplomacy and law. Since World Wars, there has been a convergence of public law and diplomacy to prevent or punish that type of behavior in order to maintain peace in the international system. So that is where actually it was justified at the Nuremberg trials, right? When Hitler's armies argued that, hey, we acted according to the law, that was the law. If we didn't do that, they would have punished us. So how can you say that we committed crimes? Well, but it was argued by then US Attorney General Jackson, who later became Supreme Court Justice, that no, you can't carry out an illegal order. When an order is illegal, if you carry it out, then you are also committing an illegality. You are liable for that, right? It's like somebody else tell you, hey, can you shoot and kill me? And you kill them and you say, hey, he asked me to kill him, so I killed. No, still you are liable. So something like that. Anyway, having said that, so this is how this is the wars that is what led to then development of human rights, international court of justice, ICJ at The Hague, etc. So since the world wars, there has been a convergence of public law and diplomacy to prevent or to punish such behavior in order to maintain peace in international system. While some acts may not be defined as crimes in every state or country, when it comes to criminal law, there's an issue here. What is considered crime is not universal, generally, except for certain crimes. Even within the United States, each state has its own criminal code. What is criminal in one state may not be criminal in another state. So even in the international system, that is the case, because crimes are defined generally based on a particular state's historically developed moral and ethical values. That is what is reflected in that. Having said that, although I said that while some acts may not be defined as crimes in every state, I use my words carefully, there are some crimes that are defined as crimes universally. Studies have been done and have found that there are certain acts that are considered crimes universally. Example, murder, rape, robbery, and just some examples. So there are many other examples. These are the ones that they have, these types of crimes have other ones that the ICC, when they formed ICC, that they have listed. Okay? And also that have been incorporated into human rights declaration as fundamental human rights, which are considered fundamental human rights. There are, other human rights that are that now. Okay, anyway. So, so having said that, now I'm going to address something else. So far I talked about also similarities, how all of the countries can agree on certain things, right? Although there are other differences, there are areas where their values, etc., can converge, and so which helps in maintaining international relations and in diplomacy, because once you identify those, it's easier to come up with the agreement, some kind of a solution. Western jurisprudence recognizes the autonomy of an individual, right? You have the freedom to do this, whatever, and also rule of law is a very basic constitutional principle in many Western democracies. That does not mean, sometimes, I see that when I talk to even my students, sometimes they think rule of law means you have to follow and obey any law that has been enacted by the legislature. No, it is not so. I gave an example before about the Hitler's armies, for example, likewise. So rule of law is based on the principle of legality. Remember, this is why I mentioned legitimacy and illegitimacy, legitimate violence and illegitimate violence. So that is the difference. So rule of law is based on that, on the principle of legality. I know that sometimes some developing countries would say, yeah, we did that because according to our law, that's okay. And we kept them in communicado, in detention for 20 years, but that's under our law, right? But that is not, that doesn't mean it is legal, like legitimate. That doesn't mean that it's not legitimate, therefore it violates the rule of law. Rule of law is based on real fairness, right? And fundamental fairness. So a law is not valid if it violates fairness, meaning fundamental fairness. That is the rule of law principle. So I'm trying to get rid of some of these concepts one by one out of the way. All right. So now the question that I want to pose to the listeners or the audience, are these concepts of peace and legitimacy, which are accepted in the Western countries, Western democracies, are they the same as those that prevail in non-Christian countries? Because the Western jurisprudence is heavily influenced by Christian doctrines. Which is very well known, well discussed thing. So, but are they the same? For example, we have to ask the question, do countries which, whether China, India, Sri Lanka, whatever, you know, or even some Latin America, not Latin America, African countries, some, are they the same? Are these concepts the same? But I'm not saying they are not, don't misunderstand me. I'm just trying to get to a certain point here. We have to understand moral values and principles of a nation or a civilization. They are influenced by, as I said before, the historical development of moral and cultural values. Those values in turn influence thoughts, ideas, and perspectives of people. So politics and laws are influenced by those. So those politics and laws of those countries are influenced by those. So this is where we see sometimes this political confrontation, conflict between developed democracies and some other countries, and sometimes there is. So internationally, then you have to solve it. We have to settle it so that you can have peace, as I said before. So that is a function of the diplomats. The diplomats can explain, but in other words, diplomats therefore also have to have an understanding of their culture, their history. The history is a very important subject to know for any diplomat in any, you know, and before you even, then this way you can negotiate, you can make the others understand. And even International Court of Justice in one decision accepted that type of explanation as a necessity to protect their people. So not in the responsibility for protect, not in that sense, a different way, economic and other, it was economic case. So in a multicultural world, can we expect that the meaning attached to words such as peace, legitimacy, order, power, conflict, war, and rule of law, whether they are the same, or whether in different jurisdictions, different places, they understand it differently? I think even in Sri Lanka, it seems, based on what I read in the news, so I may be wrong, I don't know, in Sri Lankan news, it seems that even some of the very talkative people in Sri Lanka, some of them are from, who represent NGOs or whatever, they think everything, when something happens, they say, I'm going to the UN, I'm going to complain to the UN, and because you dig a well in my land or something, you know, you violated my human rights. Okay, and you know, I have heard that there are different. Sorry, I'm not laughing at them. Don't get me wrong, but that's not right. But it's a different understanding. And but these are sometimes so-called human rights activists. They say these things. That's their belief. They are not lying. So based on their culture or whatever. And so if that is so, is it possible to have a universal morality? Now you can see I am getting to International Court of Justice and the International Criminal Court. Because the purpose, they are based on this whole notion of some kind of a universal morality. Or can we even have a universal declaration of human rights? So at least that question is answered by the United Nations itself by classifying those universal moral values as fundamental human rights. Okay. So there's a difference there. So in order to develop viable foreign policies, so if a foreign policy is to be viable, it has to be accepted by, if it is between two parties, both parties. Otherwise, it doesn't become viable, right? Even within the country or outside or between countries. In order to make foreign policy viable, and in order to conduct international relations, it is imperative that a diplomat studies diplomacy, law, and history, all three, which I discussed so far. It is very difficult otherwise in today's world, the present international system, to conduct international relations or diplomacy or foreign policy, development foreign policy, whether it is in the trade and investments area or the criminal law or human rights. At least that way you will know how to argue, how to come to a settlement, how to come to a midpoint, convince the other party. And then you can be convinced by the others. You can also convince and can find that middle ground where you can agree. That's how you get a settlement. So it's not a settlement, no one wins, no one loses. It's a settlement. Anyway, so having said that, still, next question I want to ask, before you want to think, can democracy or constitutionalism, the Western country democracies are mostly constitutionalist, right? Because they are based on a constitution, they had wars, they were there, then they created a constitution and the country was formed. So anyway, like US, for example, can democracy or constitutionalism or even Europe, can they be expected in culture areas? I mean, certain countries, the individual has not been legally detached from the group. What I mean is, I said that in Western countries, constitutionally even is guaranteed autonomy of the individual autonomy, that is privacy. For example, in the US, privacy rights are very highly valued. Okay, but when I go to Sri Lanka, no, they apparently don't care for your privacy. They ask questions that they probably shouldn't ask, and they do things, and they have it is not their fault. So the question is, because of that, such elements, or individual autonomy, or even the privacy, for example, the privacy even is also related with freedom of expression sometimes, and whether because of that they may not be accommodated as elements in a contract, even when it comes to trade and investment, and that could raise issues. The other party may disagree, or if they do this and you may not want to agree. So, but diplomats, in true diplomacy, you should be able to then negotiate And you can't just negotiate if you have no idea, if you are not conversant with that. Should it be assumed that a treaty conveys the same norms and values to non-Western and Western contracting parties? And even when you draft a treaty, when you draft a contract, either way, all these are important things that we must take into account. Can there be an effective international or world law if national or local meanings of public law are not analogous, or at least proximate? Now, let me say there are two types of laws, right? Private laws and public laws. Public law refers to generally criminal laws, etc., human rights, criminal laws, public. Then there are private laws when it comes to trade, investments, civil matters, okay? Property, etc. Though, so we have to consider both, whether there can be an effective international law or a law. That sense, if the answers to these questions are negative, if you answer no, then you have to ask, can the missing concepts be securely grafted upon public order systems built on non-legal traditions by introducing codes, constitutions, and covenants of civil liberties, and by concluding international agreements assuring respect for human rights? Can they be? I think that's where the world is moving. Eh? That's what everyone is asking when, let's say, when UNHCR, when they ask Sri Lanka to do this, do that, enact these types of laws or whatever. That's where it is coming from. Okay. And also one must consider whether international law can be viewed today as an adequate agency, for conflict control. Whether it can be or whether it cannot be. If so, do we have to devise other mechanisms? Actually, states have, right? This is where the states have begun to actually, they have done this before, but since 60s, 70s, then 80s, 90s, bilateral treaties. The number of bilateral treaties have multiplied tremendously, 10, 15, 16 times, whatever, tremendously, because they find outside of the ICJ, outside of the WTO, outside, So anyway, so then there again, that's a function of diplomacy, informed diplomacy. It's the diplomats who negotiate those, not lawyers alone. Yeah, law is also part of it, but without diplomats, lawyers will look at only in accordance with the law. Oh no, these principles, no, that's fine, no, it can't be, or whatever. The lawyers don't have that that training or that outlook that a diplomat would have. Lawyers mostly, you win or lose. Diplomats are not thinking of winning or losing, bringing about peace, settlement. So the effectiveness of a nation's diplomacy depends on intelligence, political will, sometimes military power, and capacity for survival. When you have, especially if a country, nation has threats from others, that's in the military and capacity for survival. And even within, threats can be from within. Terrorism from within, for example. Okay. International Court of Justice, as everyone knows, was established in 1945 and by the San Francisco Conference, which also set up the UN. The International Court, ICJ's primary function is to pass judgment upon disputes between sovereign states, and the disputes before the court can be brought only by the states, and states who are parties who can bring those to the court, and no state can be sued before the World Court unless it consents to such an action. So no state can be sued unless that state consents to such an action before the ICJ. And under Article 36 of the court statute, any state may consent to the court's compulsory jurisdiction in advance by filing a declaration to that effect with the UN Secretary General. And by 2000, more than 60 countries had issued such a declaration, agreeing to that. The declaration, that is the optional clause, may be made unconditionally, or it may be made on condition of reciprocity on the part of the other state or other states. Okay? Or it can be presented, and the court may bear witness and appoint commissions of experts to make investigations and report when necessary. So that's how it functions. Let me go back here. Now, having said that, I'm not going to go into detail about the ICJ. I think most listeners probably are aware, right? However, there's a very interesting academic research article published the Chicago Law School Journal at the University of, and by Professor Eric Posner, Professor Posner of Chicago Law School, and another author. They analyzed International Court of Justice decisions over a period of time. They analyzed them both qualitatively and quantitatively. In other words, very scientifically. Okay, and very time-consuming research which they did, and they came up with a surprising conclusion. Professor Posner also has been an ambassador. He's a diplomat, you know. So, so what they found out. So, so they analyzed the cases that the court has decided since it began operation in 1946 up until now. And they point out that usually the defenders of the ICJ argue that the ICJ is impartial, and however the critics argue that the members of ICJ vote interests of the states that appoint them, and however there was no agreement. So there have been empirical scholarship before this work, and they are very ambiguous, not very clear either way. And so what Professor Posner and others, what they did was they tested the charge of bias using statistical methods, statistical analysis. Okay, this is what they found. One, judges favor the states that appoint them. One, this is of the International Court of Justice. And two, judges favor states whose wealth level is close to that of their own states. And then there was somewhat weaker evidence, they say, on three, not as strong as the first two. Judges favor states whose political system is similar to that of their own states. And number 4, even weaker, judges favor states whose culture, language, and religion is similar to that of their own states. So then they say, I quote, we find weak or no evidence that judges are influenced by regional and military alignments. That doesn't happen. Okay? So why is that? What does it show us? Does that mean that the judges are biased? Not necessarily. You have to read it very carefully. And they go on to say, forgive me for reading this, the data suggest that national bias has an important influence on the decision making of the ICJ. Judges vote for their home states about 90% of the time. 90% of the time. When their home states are not involved, judges vote for states that are similar to their home states along the dimensions of wealth, culture, and political regime. Judges also may favor the strategic partners of their home states. But here the evidence is weaker because of multicollinearity. If they do, the magnitude of the bias is probably low. And then they say we have not shown in a straightforward way that judges are consciously biased. So that's very important. It doesn't mean judges are consciously biased. Yeah. All that we have shown is that the judges on the margin do not vote impartially in the manner prescribed by the null hypothesis. The motivation for their votes may be psychological or cultural. That does not necessarily consciously choose to favor a state that is similar to his or her own states, but it happens. Remember I mentioned before how our cultural values, our culture, the historical influence, maybe our religion, other beliefs, they are all developed and influenced by various factors, and we all intentionally or unintentionally, that's the way we make some decisions, and based on that. And this is why, for example, even in juries, jury studies show that based on their background, culture, different jurors make decisions differently on the same case, same facts. It's not necessarily based on the law. So the same thing happens to judges. And even in criminal law, it happens. Even the US Supreme Court, yes, it happens. Okay. It is not that they are biased purposely, but that influence is there. And this is, anyway, let me not go there. It is, they say, the judges vote in a manner that reflects their own psychological or philosophical biases. For example, suppose that the United States seeks closer relations with a poor dictatorship because of that country's useful strategic location in the war against terror. In an ICJ dispute between that state and, say, Canada, the US judge may vote in favor of Canada because of political, economic, and cultural reasons, okay, biases. All right. I'm not going to, it is much longer, but I think I made the point, I think, right? So that is why I mentioned the importance of learning history for a diplomat, and so that you understand not just the history of your country, history of other nations as well, or a nation where you are going to serve, or you are going to negotiate a dispute, or whichever. On the International Criminal Court, there are certain crimes that are within their jurisdiction, not all, because they have to be very careful, as I mentioned before, because all crimes may not be crimes in those states. However, what they have included there is still questioned by some countries, some nations. they say the mandate of the court is to try individuals rather than states, try individuals, not states, and to hold such persons accountable for the most serious crimes of concern to the international community as a whole, namely the crime of genocide, war crimes, crimes against humanity, and the crimes of aggression when the conditions for the exercise of the court's jurisdiction over the latter are fulfilled. So that's and as I said before, fundamental human rights incorporate the offenses commonly recognized by nations. So that's why their violations are very serious and they are taken very seriously. Now let me talk about move on to the other area. So I dealt with the criminal justice or criminal law area. In other words, the public law area. Let's move on to the private law area, which is the markets and investments. That is where the convergence of law and diplomacy is stronger. Okay, it has been for the last, and it's developing even stronger and stronger. It has been strong. Transnational development of markets and investments, rapid development of technology, and migration of people have led to globalization, as you all know. And rapid globalization has led to growth of states entering into bilateral, multilateral, and regional treaties in order to expand markets and substantial investments. So basically, it's markets and investments. Sometimes people refer to as trade, but real correct terms should be markets and investments. That's what they are focusing on. Okay, yeah, then trade becomes a part of that. Anyway, but this year we see convergence of private law and diplomacy. Convergence of private law and diplomacy has occurred rapidly and continue to advance in the modern times. Diplomats, treaties, lawyers, corporate actors, and international institutions, example WTO, play major roles in international relations in this area. The states prioritize market goals via national regulations, because for states, national regulations are important to protect their interests, their people's interests, maybe, their political interests. And so when that happens, it leads to regulatory control. So regulatory control of economic matters, markets, investments. And that usually create conflicts. And then it may be between the country and the corporation, it may be between nations, and then it requires international negotiations and arbitration. Now, arbitration, international negotiations, yeah, diplomacy, or if you go to arbitration or even WTO or some other, then law plays a heavier role. Okay? But diplomacy also plays a role, but law plays a heavier role. When it comes to arbitration, I must mention this. Arbitration began as a political, more than legal, a political instrument whereby we could bring about settlement rather than finding guilt or not guilt, or finding wrongdoing or not wrong, no wrongdoing. Settlement. So the diplomacy plays a very important role then, more than law. However, since then, the new developments have been to appoint lawyers as arbitrators. In cases it shows where lawyers have been appointed as arbitrators, they go for whatever decision they apply rule of law, and they try to come up with a legal solution. It may not be satisfactory, or one party may not be happy, or both may not be happy, instead of a negotiated settlement. So that must be kept in mind also if the country has a choice in the selection of arbitrators. Okay, this is where the diplomats can advise their nation. So diplomacy plays a major role in these negotiations. They need to appreciate economic, social, and cultural norms, treat obligations and international law that affect the negotiations. But by they, I mean diplomats. Diplomacy has to wade through these complex structures, economic, other structures that I referred to minimize conflict. Complex structures, national regulation, regulatory schemes, laws, treaties, so on and so forth. So they have to wade through these complex structures carefully to minimize conflict and to find common ground that would protect the interests of the parties involved. I am not saying party involved, parties involved, because that's how negotiations work, right? The settlement works, both parties, both 2 or 3 or whatever parties. So diplomacy and law, convergence of diplomacy and law, and law must overcome competing social regulatory concerns, protect rights and privileges of stakeholders, for example, traders and investors, prioritize market and investment access, and legal and institutional challenges. So the 1947 GATT, General Agreement on Tariffs and Trade, it balanced free trade and regulation. That was the first attempt, and it worked really well. It was a very liberal agreement. It balanced free trade and regulation. It gave priority to domestic policies and provided for intervention to safeguard domestic stability. It is an immense task to balance the demands of market investment values with legitimate regulatory ideals of social needs. The objective of arbitration, as I said, is to settle disputes, not to make legal precedents. Legal cases, they are making legal precedents. The difference is a settlement is addressed to the past. You are settling on what's based on something that has already been done. Legal decisions are addressed to the future. They create precedents that will be then followed as well. So that is what lawyers address always to the future in cases, not past. So objective of arbitration must be settling a dispute, not to make legal precedents. But the WTO, World Trade Organization, they come up with remedies, and their remedies are addressed to lawmaking, creating a precedent. This is the main complaint that some countries have against the World Trade Organization, WTO. They act like a court for some reason. I don't think that was the objective when it was created, but that's what is happening. However, when lawyers are appointed as arbitrators, they are influenced by legal norms. Again, as I said before, so countries prefer, that's why countries now prefer arbitration rather than going to WTO or other judicial mechanisms. Many developing countries who are former colonies seek political independence and economic sovereignty. Sri Lanka has done that after the independence. Even in the 60s, 70s, it was very high. However, due to their lack of productive capacity, the developing countries are dependent on investment of economically rich countries. This is why again this convergence, discussing convergence of law and diplomacy is very important. After independence, many of the former colonies, they began to expropriate foreign assets. It became a very common practice, especially among Asian, African countries, including Sri Lanka. They expropriated oil assets of American Shell, American Oil Company, and Americans imposed restrictions on Sri Lanka then. And that was the first time they did that for a country. In the history, the American Congress passed a law. So anyway, because of that, developed countries and corporations, multinational corporations that may provide capital or help expand markets, they require guarantees from nationalization and freedom from interference by local authorities. It is very important for countries like Sri Lanka to guarantee them freedom from nationalization, expropriation, and the freedom from interference by local authorities. Otherwise, however much you shout, we need investment, investments may be very slow to come, or no, not coming, I don't know, whichever. Therefore, so this is again the job of diplomats to, when I moved, I think the camera lost the focus, right? This is very important for diplomats, the foreign policy personnel, diplomats, to educate and convince their states, their appropriate agencies, whoever. So this is also why many of those countries and corporations prefer bilateral treaties, because bilateral treaties, they can make them investor friendly. They can include investor friendly provisions in them, and they can also include private arbitration mechanisms that will ignore state-to-state public international law standards. That is the trend. For example, China wanted bilateral treaties with Sri Lanka. India wanted bilateral treaties when it came to the port, etc., as you know. Since 1980s and 90s, bilateral treaties in foreign policy and journals law, we normally refer to them as BITs, B-I-T-S, bilateral treaties. B-I-T, bilateral treaty, S is BITs, plural. Since 80s and 90s, BITs have tremendously increased. Many Southeast Asian countries became industrialized by entering into BITs in the 80s, 90s, Singapore, others, many others. We missed the bus. Sri Lanka, I mean. Unfortunately, Sri Lanka failed to create policies linked to export growth and market orientation. Diplomacy needs to play an influential role there. I hope Sri Lankan policymakers, foreign ministry, and others will listen to this, will watch this, George. Okay, I'm all coming to the end now. Presently, developments of international law seem to strike a reconciliation between market goals and public interest. So presently, that's very important. That is also the countries have to, right? You try to strike a reconciliation between market goals and public interest. That happened in Sri Lanka even recently. The public interest and market goals when it comes to port and other, American investments, etc. This is a result of convergence of law and diplomacy. If it comes as a result of convergence of law and diplomacy, the result would have been more for settlement. I'm doubtful whether that's what happened in Sri Lanka recently. I'm not sure. I may be wrong. Because the result would have been different. Finally, I must say, I must emphasize the importance of understanding convergence of law and diplomacy and take appropriate steps such as creating a separate foreign policy legal department within the foreign ministry. This is happening in many other countries who are in international trade and investments, who are seeking or who are investing, and train diplomats in negotiating international state and trade relations. That is, whether it's bilateral treaties, multilateral treaties, or even other cases that come under international norms. They have to work with lawyers, and the foreign policy, the diplomats, they all have to work together. It is very important. Sometimes a cabinet minister may not be competent in that. It's not something wrong with the elected people, but officials should be competent, and this competency has to be improved if any developing country to be advanced. Okay, thank you very much.
That was Professor Karunaratne Hangawatte, Professor of Criminal Justice at the University of Nevada in Las Vegas in the United States of America, our guest on this Awarelogue special, where we focused on law and diplomacy. Join us again for more specials brought to you by the Awarelogue Initiative.